rise. Have a seat. Come on up. This is 24 CV 52569 Jill Bong versus Douglas County School District number 15. I have today set as a status check. There are several motions filed. Are the parties intending to argue the motion or any of the motions at this point, or do we need to set a date for the motions?
Good afternoon.
I'm ready to argue all the motions today.
I don't know that we're gonna have time to get to all of them, but what motions are you prepared to argue today, Ms. Bong? You said all of them.
All of them.
All of them. Okay, Mr. Is it Mercereau?
Mercereau, Your Honor. Yes, good afternoon. I am prepared to argue them all as well, and frankly, I don't know that they'll take a whole lot of time. I think the issues are pretty clear. So if the court's willing, I think we can go through them all.
Okay, Ms. Bong, why don't you start with your first motion?
Well, actually, it's Mr. Mercereau's motion to dismiss that's the first motion, but I'll be happy to start it.
That is correct. Yeah, I apologize. Mr. Mercereau, go ahead and tell me your basis for your motion to dismiss.
Thank you, Your Honor. This is a public records case, and in it, Ms. Bong is alleging that the fee that was charged to her was unreasonable under the Public Records Act. The case law, and in particular the Defense of Animals v. OHSU case, holds that it's proper for a court to consider the reasonableness of a fee and that the fee needs to be reasonably calculated to reimburse the public body for its costs. That's also what the Public Records Act says in 192324. So here, Ms. Bong pleads in her complaint the following facts. Number one, that she made a public records request. Number two, that she was provided with a fee estimate for that request. Number three, that she paid the fee estimate. Number four, that she received the records that she requested. And number five, that after she received the records, she inquired with the district about the calculation of the fee. And she received information both from an administrative assistant in the main office and directly from the district superintendent that the cost that the district incurred in responding to her fee was actually greater than the $40 estimate that she was given and that she paid. And all these facts are in her complaint, Your Honor. They are allegations, and on a Rule 21 motion like this, they are presumed as true. And so there really is no basis to conclude that the fee was anything other than reasonable because as Ms. Bong pleads, it was clearly explained to her that multiple people inside the district beyond just the administrative assistant were involved in gathering the records. And that even though the costs to the district were greater than $40, she was not going to be charged an additional fee. She pleads and alleges that she was entitled to a refund, but given those facts that she has also put in her complaint, it's clear that the fee was reasonable and that she was not entitled to a refund. And that's really the beginning and the ending of this case, Your Honor.
Ms. Bong?
Yes, the fact that the school just claims that the fee was reasonable does not make it reasonable. In the state versus Get to View, I don't know how to pronounce the name, I'm sorry, I did state it in my motion to compel. The court has ruled that just because someone has paid the fee and received the product, the item doesn't mean that the fee was reasonable. So that is the main reason of the lawsuit today is they could only justify 40 minutes of the secretary's time. So 40 minutes of what the secretary makes came to about a little bit over $13, and the school policy was that the first 30 minutes is free. So they should only have charged me $3.39, but they charged me over 10 times more. That's not a reasonable fee. And just proclaiming that they say it's reasonable doesn't mean it's reasonable.
So you are saying that the district policy, I think one of the, first question about the district policy is, I think when I initially read what it says is that you won't be charged if it is effectively if it's less than 30 minutes.
Correct.
That doesn't say that the first 30 minutes is free. It just means that the charging is activated if the effort takes more than 30 minutes. Do you disagree with that?
I disagree. I'm interpreting it as if it's more than 30 minutes, then the first 30 minutes is complimentary. And so Miss Art, the secretary, said she spent 40 minutes. So the first 30 minutes is free, last 10 minutes is charged.
And let me see if I can find where I first read that. I think it said something to, and I haven't seen the actual, I'm just relying on what's in the motions and the pleadings, I should say. But I think it says you won't, in the event that, or here it says right here, it looks like it's quoted, where the labor effort exceeds 30 minutes, labor, material, and out-of-pocket charges will be reimbursed to the district. Labor will be calculated at the hourly rate of the employee affected. And so the first thing that I want to make sure I have square is that doesn't appear to me to say that the first 30 minutes is free. What it appears to me is saying you won't be charged unless this exceeds 30 minutes of time, labor, and effort.
Okay, even if that were the case, then it would be 40 minutes, which would come to about $13 of the secretary's time, considering she's paid about a little bit over $20 an hour according to the pay scale. So even still, at about $13 charged, they're still charging me 3 times more the actual cost.
Okay.
It's not reasonable.
Okay, well, I'll come back to that. Let me go to Mr. Merzaro, and you tell me if I am understanding this policy correctly, Mr. Merzaro.
I think you're understanding it perfectly reasonably, Your Honor. The policy reads where the labor effort exceeds 30 minutes, labor, material, and charges will be reimbursed. So that really divides public records requests into 2 categories: those that take less than 30 minutes time and those that take more. The first category does not incur a fee. The second category does. So it just doesn't read as if you get 30 minutes of free staff time.
Now let me, because I want to make sure that, because there's been a lot of stuff filed in this case, and I just want to make sure that I'm tracking, because Ms. Bong, what the court would reasonably interpret this policy to be attempting to address would be the event where you come in and there's a secretary at the front desk and you need, I don't know, some record that is easily accessible, for which the secretary goes to the back, retrieves a file, brings it to you. That takes 5-10 minutes at most. And in that regard, it's almost a policy that is aimed to not require reimbursement for what are ordinary or routine administrative functions of, say, a secretary. Do you recognize that, or am I missing something there?
I don't agree with that, but even if we do take the court's interpretation of policy,
what is your interpretation of it?
That the first 30 minutes is not charged, regardless of whether it's more than 30 minutes or less.
Okay, but your point still is, even in the event that
Correct.
it is what the court is looking or suggesting might be a reasonable interpretation, is that then it becomes about $13 and you were charged $40. Now, I will ask you, do you presume that, did you receive an well, you say in your complaint that you received an explanation that other people were involved?
That was very vague and very opaque as to who exactly was involved and how much time was involved. They wouldn't break it down. They wouldn't tell, say who else, took part in the record search, how much it cost, how much each person, spent on it.
Okay.
And it was a very simple request. It was just asking the school how much they spent on online math tutoring services for, I believe, the past 2 years. It wasn't something complicated. It shouldn't have taken more than 40 minutes. In fact, I think 40 minutes was really an overestimate of how much time it should have taken.
Okay. What were the records that were requested?
Just requesting how much the
Oh,
school paid for
that's
online
right.
math tutoring services for, I think, the 2 academic years, which was a very basic question. So it shouldn't have taken more than 40 minutes, if that, unless the school's records are so disorganized, which then, the public shouldn't be paying for the school's disorganization.
Okay. Now, what is the authority that mandates that the district provide perhaps I don't know, an invoice of the time or a breakdown of the time and effort that was spent? And why is the explanation not reasonable?
I believe that was like in defense of the animal case.
Okay, do you have the citation?
I don't have it offhand, unfortunately.
Mr.
It is,
Mesereau,
Mr. Mesereau actually mentioned it in his.
What is that case citation, Mr. Mesereau?
Yeah, it's 199 ORAP 160, Your Honor. It's Defense of Animals versus OHSU. And that case really talks about how a court determines the reasonableness of the fees in terms of, the employees that were involved on the project, their hourly rates and so forth. It doesn't, as far as I'm aware, that case doesn't require that the requester be given a breakdown like this. I mean, of course, that case was about thousands and thousands of dollars and thousands of pages of records, Your Honor. So I don't know how applicable it is here. But
Okay,
I'm not
give me
aware.
that site. Give me that site one more time.
199 ORAP 160.
Or at 160?
Yes.
Oh, I put OR. Okay, hold on a second. Of course. 199. All right. And so, Ms. Bong, do you have an authority that tells me that, like, for example, a statute or a case that says that in the event in the event of a request, well, I guess what I'm really trying to ask is, do you have any authority that suggests that the school district is charged with providing a breakdown for the efforts taken to fulfill the request that you made?
As far as I know, they don't have to give like a full breakdown, but there's no transparency in what they charge, which is the basis of the Public Records Act. They can't just say, oh, multiple people worked on it and we spend more time than what we charge. That's not transparent. It doesn't tell us anything. In which case, any public body could just say, oh, we spent this much and we're going to charge you, some arbitrary amount. I mean, there has to be some transparency and some calculation as to who did what so that the fee is reasonably calculated to reimburse the public body for the actual costs involved, which is what the statute is.
So is this ultimately, are you all telling me ultimately that reasonableness of the fee is not, there's no mechanism for determining that unless and until a court is reviewing the case to determine for reasonableness? Is there no mechanism for determining reasonableness, Mr. Mesereau?
Well, Your Honor, in fact, the district attorney, who normally would be kind of the intermediate step here, is not empowered by the Public Records Act to determine the reasonableness of a fee. So frankly, I think you're probably right that the only body that can determine the reasonableness of a fee is a court like yourself. However, I would suggest and argue, as I've argued in my motion, that there's no basis that Ms. Bong has not stated a claim, that Ms. Bong has not provided a basis to determine that the fee was unreasonable.
I understand that. I'll get to that in a second, but I'm just trying to make sure. I don't. The court and I venture to guess that most courts probably don't deal with this on a routine basis. So I want to make sure that I'm understanding exactly the arguments. So then I guess one of the questions I have, Ms. Bong, is then if there is no mechanism for a determination as to what is reasonable, then the district is then left with the responsibility of providing you some explanation.
I would agree, Your Honor, that would come to the breakdown, because otherwise, how would we know whether it's reasonable or not?
Well, I don't know. I don't know that I agree with your characterization of breakdown. I think an explanation is probably appropriate. In your complaint, you say that you were provided an explanation. Now I recognize that your point is that you're not satisfied with the nature of the explanation, but I don't know what compels them to provide you with a breakdown or an itemized cost allocation for the effort. And so one of the things I'm saying is help me find where that is, and I'd be happy to look at that, but I'm not aware of, and I don't see anybody offering me a authority to show me that the school was responsible for providing an itemization of their efforts.
Well, the mechanism for determining whether it's reasonable or not would be if they could just quantify that, and not just in generic, well, we spent number of employees spend an unknown amount of time on this, and therefore it's reasonable. For example, the secretary was able to quantify how much time she spent on it. She said 40 minutes. I can find how much she makes, and therefore I could quantify that the actual cost was about $13. But they charged $40, and they couldn't quantify who else worked on it or how long they worked on it. So it can evidently quantify who worked on it, right? I mean, that's not an unreasonable request. So she could tell me in 40 minutes, she spent 40 minutes on it, but after that, they couldn't tell me, who else worked on it. I mean, I don't expect a, line-by-line breakdown, but they should be able to say.
Well, okay, that might help me. What were you expecting?
They should be able to say, this person spent this much of time working on the project. And if it was, justifiable, then this lawsuit wouldn't be happening. But they obviously can justify it. That's why they're, just giving vague reasons that it's reasonable without any quantification of, who spent what, other than the secretary who said she spent 40 minutes of the time. I mean, it's not something unreasonable to ask of, because they should know how much time they spent on the records request, which was like I said, it was a very simple request. So 40 minutes should have been more than sufficient.
Okay. Mr. Mergereau, were you getting the different part of the argument here?
Well, I guess, Your Honor, what I'm hearing is a lot of the district should have done this. The district, didn't satisfy my concerns. These are all sort of subjective evaluations of Ms. Bong about what she's receiving. The question in a lawsuit like this is, what does the law require? And the district is clearly satisfied its obligations under the Public Records Act. It followed the process. It produced the records. It gave her information as to the derivation of the fee. I think what Ms. Bong really is asking for is what we would call a line-by-line estimate, or some kind of written document that specifies exactly who spent how much time, and the law just doesn't require that. So I just don't think she stated a claim here, Your Honor.
May I say something, Your Honor?
Yes, please.
So I think we're getting to the weeds of the situation that we're arguing about whether the district needs to produce a line-by-line. The question is whether they charge a reasonable amount to reimburse it for its actual costs. And right now, they're not showing that they're charged a reasonable amount to reimburse it for the actual cost, which they have only quantified as about $13 for the secretary's 40 minutes.
Right. I'm reviewing 192, 324. Just a moment. All right, now I'm looking at 192, 324, subsection 4, subsection C. And tell me what I am reading, Mr. Merzero. This says the public body may not establish a fee greater than $25 under this section unless the public body first provides the requester with a written notification of the estimated amount of the fee, and the requester confirms that the requester wants the public body to proceed with making the public record available. Now, what I think I know of the case is that the $40 fee was paid up front, and in the event that there was something to be reimbursed, that that Ms. Bong would have been reimbursed in theory. But I guess where I'm going with this is, does that satisfy subsection 4C of this statute, that effectively the $40 was paid up front, and the payment is the confirmation that Ms. Bong wanted the public body to proceed with making the public record request?
Yes, that's correct, Your Honor. And this comes on page 2 of plaintiff's complaint, paragraphs 5 and 6. She alleges that she made a written request for these records. And then the next paragraph says, on payment of the $40 fee quoted, the school district provided the requested records. So that indicates that section C of that, 4C of that statute was followed. The fee was going to be greater than $25, so they reached out to her, notified her that that's what it was going to be, $40. She paid it, and she got the records.
Do you agree with that, Ms. Bong?
Yes, Your Honor, that's not the issue at hand.
I understand that. That was in reading the statute. Now, what the issue at hand really is 4A, and that is the public body may establish fees reasonably calculated to reimburse the public body for the public body's actual cost of making public records available, including costs for summarizing, compiling, or tailoring the public records, either in organization or media, to meet the request. Now, the language, of course, is what I'm focused on, and the particular phrasing that I think needs to be addressed is reasonably calculated. Now, in cases, I think to Mr. Mergero's point about the OHSU case, it's not a different analysis, but you have a larger, I think, sort of margin for error when there are fees that are excessive relative to what we're dealing with, right? So in the OHSU case, I haven't read the case, but presumptively that I think that what we're talking about is thousands of dollars, right? And in this situation, what I'm really talking about is reasonable, not precise, and calculated, not perfect, right? What I think I'm reading here is that the public body, I think in a perfect world, would be able to provide the information you're talking about. But the fact that the legislature believed that reasonable calculation was appropriate means that there are some variables that aren't necessarily considered here, right? The ability to provide a precise estimate or actual cost, and also the burden on the public body in discharging the duties that they're required, in addition to dealing with administrative tasks such as these. And so, while I think one of the things I hear you saying is I was not provided a explanation as to how this fee is broken down. I having a tough time understanding how the fee is not reasonably calculated to reimburse the public body.
Because what they could justify was $13, and that's what they could quantify. The actual cost was about $13, and they charged $40, which is more than 3 times its actual cost. Yes, the amount is small compared to the other case, which was thousands of dollars.
I don't want to get hung up on the small part.
Right.
Because the reason I brought that up is in the event that that I think the distinction that I probably didn't articulate well is that when someone's charged thousands of dollars, there is that is prohibitive in a way that the fee we're talking about isn't. And thousands of dollars is, when I read the statute, something that probably has to be justified in a different way than $40, right? When I look at reasonably calculated, right, I think that in the event that it was $10, let's say, right, and the actual cost actually turned out to be $5.50, I don't think you have a foul of the statute, because I think it was a $10 fee is reasonably calculated.
I would respectfully disagree, Your Honor.
Okay.
That's double what the actual cost was. That's not reasonably calculated. We're talking about small sums of money, but when you talk about percentages, that's a big difference there. That's a big disparity.
Okay, I don't disagree, but I don't think that the focus is on necessarily being precise. There's a reasonable calculation standard that we're talking about, though.
So let's say in this case, the fee was $13. How is $40 a reasonable calculation? That's more than 3 times more. That's not reasonable.
Well, that's disregarding that there's been an explanation, though. And I'm not trying to argue this. I'm just trying to make sure that I understand that that you're saying that you were provided an additional explanation that isn't itemized, correct?
I'm not asking for an itemized explanation, but there should be some kind of explanation rather than just a vague, multiple people worked on an explanation.
Okay.
Because, as I said, the secretary could immediately say how much time she spent on it. Everything else is arbitrary and vague, so I don't know if it's an actual cost that they incurred. They're just saying that they incurred it without any justification for it.
And to be clear, I understand the frustration that you're talking about. I am really limited to law and facts, though. And before I go any further, I want to hear from Mr. Mergereau based on 4A, sub 4A.
Right, Your Honor, and that requires the district to calculate the fee based on its costs and to reimburse it for its costs. And I think it's quite clear in Ms. Bong's complaint, she was given information as to the derivation of the fee. The fact that she chooses not to believe that information is not really germane to the legal issue involved. I think she just has not given the court any information that would suggest that the fee was not calculated reasonably. And for that reason, she hasn't stated a claim.
Okay. Anything else, Ms. Bong?
I'm sorry, so he's saying that that I didn't state claim because the fee was not calculated reasonably? the fee, I'm saying that the fee wasn't calculated reasonably because they couldn't justify it. They charged me 3 times more than what they said, they told me the actual cost was. So I have stated a claim.
Okay. Well, as it is pled, I don't think you have stated a claim that for relief under RS 192.324. I will grant leave to replead if you believe that that is something that you want to do, but I'm going to grant the motion to dismiss at this stage. And the reason why is that I find that the public body has established a fee that is reasonably calculated to reimburse the body for its actual cost. And I don't find anywhere in this particular law a requirement of an itemization. I know you're not asking for that, but a satisfactory explanation as to what that fee was based on. Now, that isn't to say that I should say, I don't find that there's anything in this law that requires anything other than what the public body in this case has already done. So the motion is granted for failure to state a claim, but you do have leave to replead in that regard.
Your Honor, may I say something else
Yeah.
before we do that? And what I wanted to say was also that these are factual disputes that are not really suitable for a failure to state claim at this point in time. I mean, I'm saying that it was unreasonable and they're saying that it's reasonable. Those are factual disputes that should not be determined at this point in time.
I don't think what I'm determining is a factual dispute. What I'm taking is your complaint as is pled and as if the things that are being pled are true. They don't state a claim for relief, but I am actually, as I said, I am granting leave to replead if you decide that you want to do that. So this is separate from what I think you might be talking about is something more akin to a motion for summary judgment in which I would determine a factual dispute here or whether or not a factual dispute exists. That's not what I'm doing here. Okay.
Thank you, Your Honor. I'll prepare an order.
Yeah. Thank you. Okay.
What time frame would the deadline be to replete?
30 days.
30 days from
Yep.
today?
From today.
Okay.
Okay.
What can I replete before the order is filed?
Yes, that is. I've already made the order, and Mr. Mergereau will file an order commensurate with my ruling, I should say.
All right. Thank you, Your Honor.
All right. Have a good day.
Thank you, Your Honor.
Yep.